was already argued from our side, my lord.
You just have to, I think you have to refresh this matter. You see, was heard then.
A long time, my lord.
Exactly.
The matter came.
You say long.
Because I have already concluded my submission, my lord. Today I am not prepared also.
Then in that case, have it next week, Monday, if my learned senior
We'll have it on Monday.
It was actually reply by them, so I did not go.
We also vaguely we recall the case, you see, but then
Let it come on Monday, my lord.
pre-made by the parties. This is matter on Monday.
Any mention?
Please, Your Lordship. Lordship, I beg to mention item number 5, my lord. I've informed the other side. And for the private respondents, number 8 to 12, my lord.
You're for respondent?
Yes, madam. Private respondents. Matter may kindly be taken up after 2 weeks, madam.
Respondent number?
Respondent number 8 to 12, private
8
respondents.
to 12.
8 to 12.
Mr. Direct Counsel for the private respondent 8 to 12 has sought for accommodation on grounds of personal difficulty. Mr. Direct Counsel for the petitioner has no objection to the same. Accordingly, prayer is allowed. This is matter after 2 weeks.
Much obliged.
Lordship, I beg to make a mention for item 2, Lordship. This matter has been sent for mediation, but Lordship, but not succeeded, Lordship.
What is this WPC 264?
So it's a connected matter.
But why is not listed?
It's item number 1, Lordship, 264. It's an item.
Okay, okay. So 1 and 2 connected.
Connected, my lord.
You're in which?
I'm only in item 2, Lordship.
2.
Petitioner.
And who's in 1?
Item number 1 is the.
Mr. D. Wajri, lordship.
Okay. He is not here.
He's not present, lordship.
Who's appearing here now? Who's here for item number 1?
Item number 1, only the respondent is here, lordship. I'm for item number 2. He is the petitioner for item number 2.
What is this case about?
This is regarding the benefit, Lordship, which has been denied to the petitioner, Lordship. Is the petitioner herein, they are working in the Mutai, Lordship.
Okay.
But the benefits of the petitioner has been denied, Lordship.
What benefits? Petitionary benefits or?
Casual benefit and the benefit, Lordship.
What's casual benefit? So that means these 2 cases are interlinked.
Lordship, they are, my lord.
From Muda.
Impugn order is the same. Any impugn order?
No,
There's no impugn order, lordship. They're seeking service benefits, HRA, DNS allowance, Hill allowances, etc. Lordship.
This is the third round of litigation. What has happened is in the first round of litigation there was some direction passed, which lordship they did not agree. Then a contempt petition was filed. Then they passed an order to give us the amount in Minimum Wages Act. Subsequently, what they have done is they have stopped those benefits, lordship. Against those, lordship, we have come before the lordship.
Okay.
So this petition and item number 1 he has come alone, lordship. In item number 2, lordship, we are 13 of us together, lordship.
Okay, okay.
Lordship. That is the one.
On pre-made by Mr. the counsel of the petitioner, matter is adjourned. This is him after 2 weeks.
Much obliged, lordship.
In fact, lordship, this matter was referred to mediation. Lordship, in fact, the secretary of Muda appeared and he made a statement that he doesn't have the power to, and on those lines, lordship, the mediation was closed and it has been referred back today, lordship.
Okay.
Lordship.
So I similar for item 3 as well, Lordship.
Then nothing is left.
So we fix it after 2 weeks, Lordship.
You are for?
I'm from respondent 4 to 80, Lordship.
4 to 8.
4 to 80, Lordship.
For a district council, my lord.
On pre-made by the learned counsel for respondent 4 to 8, seeking accommodation on grounds of personal difficulty. Matter is adjourned. This is him after 2 weeks. Nothing is left.
Item number 4.
Yes, who's appearing?
Mr. SN.
Yes, this is the matter where hearing is already, completed in the other court.
Yes,
It was a part heard matter for the other court.
Part heard.
It was heard to some extent.
Something with 5 and 6.
No, you see, I think
The learned senior has pointed out in the last occasion that according
no, if the parties agrees, if the party agrees, then this court will release this matter.
Well, we are so far 5
No,
and 6.
no, we're talking about 4, Mr. Don't jump the gun.
I'm sorry, brother. Item number 4, Lordship, is subject to your Lordship coming.
No,
The
but
other counsel has raised that
he has raised that he wanted, but then he should have been here
he's
today.
supposed to be here, Lordship. He's supposed to apprise this honorable court.
You are also agreeable.
Yes, Your Lordship.
Okay, Lordship, with this court or in the other court.
Parties, learned counsel for the parties have submitted that this matter was earlier taken up by a coordinate bench of this court, wherein the matter has been heard substantially. Argument already completed.
No, it was part heard matter.
It was heard at some length.
Was heard. Gunung Tunggal? Coordinate bench of this court, I under bracket HS thank you.
Yes, Lordship.
Just thank you. G. Close bracket. In which the matter was heard substantially and about to be concluded. Pray submit that this court may allow the matter to be, since the matter is since the matter was practically part heard by the earlier bench, it is prayed that this matter may be released by this court. On consideration of the submission made, this court hereby release this matter from this bench. Next, please let this order be placed before Honorable the Chief Justice for necessary orders on the administrative side. Order accordingly.
Item number 6.
Well, Lord, I have no issues. My Lord, you can take up the matter here.
Yes, Mr.
My lord, I also have no issues. I'll start. So, my lord, here the primary questions, my lord, and which my lord will have to decide on is the test identification parade, my lord. TIP itself is not a substantive piece of evidence. So, and it's only a corroborative, my lord. So, can a judgment, can a conviction be based solely on TIP? That's question number 1, my lord.
Yes.
And the second part is, my lord, can a judgment sustained? Can a conviction judgment sustained when the TIP itself is conducted in a manner, my lord, not in accordance with law, my lord? So these are the two questions, my lord. So basically, my grievance here is, my lord, and where I say the judgment, the impugned judgment is bad in law, because, my lord, this facet, this very important facet, has been overlooked while convicting us under section 304, my lord. 304, attempting Under section 304, my lord.
304, not 304B.
304 IPC, my lord.
Not-
Culpable
not
homicide.
not the second part.
No, second part. Culpable homicide not amounting to the murder, my lord. So, my lord, I'll just bring the facts of the case, my lord. My lord, this incident happened on 20th of March 2011. That was a Holi, my lord. That's a Holi, while celebrating Holi, my lord. And the place of incident happened in Molanghat. It's a parking space, my lord, parking lot. In this parking lot, my lord, the deceased Rijit Kurkalang, my lord, was collecting a parking fees. And the story of the case is, my lord, and he went and asked for a parking fees from two persons, my lord. One is Komios Dotodong and another one is Kraukupar Wanyang, my lord. Now, Kraukupar Wanyang is the driver of the taxi and Komios Dotodong was sitting there. Now, because of this issue, my lord, parking issue, there was a heated exchange of argument, and in fact, there was an altercation also. Now, after the altercation, everything subsided, and according to the prosecution story, my lord, two groups came back again. One from Rijit Kurkalang called his brother and one of his friend. They came, and the other is Komios Dotodong and Kraukupar's gang came. So there was a fight. In this fight, Rijit Kurkalang, deceased, my lord, who was the parking lot fee collector, sustained head injury and succumbed to his injuries in the hospital, my lord. So this is the facts. This is the facts of the, in short, my lord, this is the facts of the case, my lord. Accordingly, my lord, there was an FIR. Initially, the FIR was lodged under section 302 and we got arrested, my lord. Of course,
How many?
3 persons were arrested, my lord. Initially, 2 persons were arrested. That is, Komios Dotodong and Kraukupar Wanyang were arrested. And Louis, which I am presenting, my lord, before my lord, Louis Dotodong, he was not arrested, my lord, and he secured anticipatory bail. Subsequently, my lord, anticipatory bail being cancelled, my lord, he surrendered. So in that way, my lord, three persons were arrested, my lord, in this. So, my lord, now I will just take my lord to the paper books, my lord. I'll take my lord to the complaint first, my lord. The complaint is at page 1. Page 1, the typed copy is page 3, my lord. Page 3. And this is address. Now, my lord will see who is the complainant, Babijit Kurkalang. Babijit Kurkalang, my lord, he was also, he's the brother of the deceased, my lord, who also came into the spot at the time of altercation, my lord. Now, sir, may I read, my lord? With reference to the subject cited above, I, Mr. Babijit Kurkalang, would like to inform you that when I was collecting the parking fee at Sora bus stand from a local taxi bearing a registration number ML057493, the people who were inside the taxi, around 6 or 7 of them, instead of giving the parking fee, they were making trouble and threatened me. After some time, same group came with hammer, stick, knife, and they severely assault me, my brother Rijit Kurkalang, resulting his death. Therefore, I would like to request you to take stern action against them as per legal, especially as I've lost my brother. My lord, kindly note now. What he says, 2 things he said, my lord. There were 6 to 7 persons sitting in a taxi when I went to collect the parking fees. He said, and then he says that this group later on came back armed with lethal weapons and started assaulting, resulting in my brother died. 6 to 7 people sitting in taxi, it says like that. Now investigation completed, my lord. And what is the finding in the investigation, my lord, will find at page 25. This is the story of the prosecution, my lord, the IO. Page 25, my lord, is good.
Yes.
My lord may kindly skip paragraph 1, paragraph 2. My lord may come from, my lord has got the final fight. The final fight.
Yes.
My lord, from here, the final fight, my lord. The final fight took place between both the parties, and one parking collector sustained injury and other one fled away. After that, all the three people, Louis, Comius, and Krau Cooper Wanyang, came to Cantonment Beat House at around 3:30 p.m. on 20/03/2011, all and reported the matter when Louis heard the news at about 6 p.m. that the parking collector who was admitted in the civil hospital expired in the hospital. He took the mobile of Sri Comius and Krau Cooper and disappeared from Cantonment Beat House. Sri Louis Dudorong was forwarded to the Honorable Court on 29/07/2011, and on 26/8/2011 a TIP was held in jail premises where the witness Sri Sylvester Khongsit identified the accused. Sylvester Khongsit is one of the Kurkalang's friend who came to the spot where the fight was going on, my lord. So he's so projected to be a ocular witness, my lord. Now next, my lord, Sri Louis Dudorong was released on bail by the Honorable Court on 31st October 2011. The call details of mobile number of Louis so-and-so, Sri Comius and Sri Krau Cooper was collected on 05/11/2011, and all the call details from the involvement of Sri Louis Comius Dudorong in case. Interestingly, Sri Louis could not produce his mobile at the time of arrest, telling that he lost his mobile set. This is also an important point, that the deceased Kurkalang was the only member who earned for family and surviving young wife and a baby. Conclusion, my lord. Now, at the end of the investigation, it is to be noted that the case is registered under section 302/34 IPC, but during investigation it was revealed that it is not a case of pre-planned murder, but the crime has placed under heat and sudden provocation. This is a case of culpable homicide not amounting to murder. The act has been done by injuring on body, as it was likely to cause that one of the young men who is covered under section 304/34 of the IPC. The weapon mentioned in the FIR could not be recovered. FSL report has not yet been received. It will be produced in the court after being received from FSL. Sri Krau Cooper Wanyang was not identified in TIP by the so there is insufficient of evidence against him. I therefore like to note here that a prima facie case under section 304 has been well established against the arrested accused number 1 Sri Comius and Sri Louis. So I send up to your honorable court to stand trial, and Sri Krau Cooper Wanyang may kindly be discharged from the liabilities of due to insufficient of evidence, as the witness failed to identify him during a TIP held in jail premises. Witnesses noted in separate sheet will prove the evidence so and so. Now, my lord, the prosecution itself points out that this is only a TIP case. Krau Cooper Wanyang, whose taxi was broken, who was there in the fight, they says that the witnesses have not failed to identify him. Therefore, I am discharging. Why? Because there is no sufficient evidence against him for want of TIP. The witness could not identify him. So the other persons, the witnesses identified him. Therefore, there is a case against them. There's a prima facie case against them. Completely, absolutely nothing has been discussed. Why prima facie case? What material bring you to prima facie case? Nothing. Only TIP. It says that. Now, my lord, will see page 28, my lord, is a type copy. My lord, before that, I'm sorry, my lord, I was trying to, page 38, my lord, the charge. Page 38, page 38, my lord. This is the charge, my lord. Now the charge sheet has been submitted, my lord. The charge sheet has been submitted under section 304 and 34, my lord. And thereafter, after the court took cognizance, this is a charge, my lord. The charge, my lord, I, A.M. Ripna, session judge, is so and so, so and so, and two accused persons, that on 20/03/2011 at around 2 p.m. or 2:30 p.m., both of you, Comius and Lewis, had severely assaulted Shri so and so and Babiji at Molongat. After a quarrel occurred between both of you and Shri Rijit Kurkalang and his brother Babiji Kurkalang, as a result of injury, the victim led Rijit Kurkalang was admitted to civil hospital where he succumbed to his injury on the same day at around 6 p.m. and thereby both of you have committed an offence punishable under section 304/34 IPC, which is within cognizance of this case. I hereby direct you to be tried under the charges. So, my lord, the charge has been framed under section 304 and 34, my lord, of the IPC, my lord. Now, the prosecution has examined, my lord, 14 witnesses, including the IO, my lord, 14 witnesses. But out of these 14 witnesses, my lord, the star witnesses, the ocular witnesses, my lord, the important one is Babinjit Kurkalang and, my lord, Sylvester Kurkalang, my lord. Sylvester, my lord. So, my lord, may I just like to draw my lord's attention to the evidence of Babiangjit, my lord. Where is that? Page 60. Page 68. Page, my lord, kindly come to page 68, my lord, page 68. He was examined as PW9, my lord, page 68.
Okay.
I'm just jumping the sequence, my lord. I'll come back to the less important witnesses at the end, my lord. But these are the important witnesses. That's why I'm pointing out to my lord this. I'm taking my lord to these witnesses first, my lord.
Yes.
My lord, may I read?
He is the complainant, isn't it?
Yes, my lord, Babingjit, my lord. My lord, I have received a summon to appear before this court today, and I am also aware as to why I have been summoned before this honorable court. The instant case is with regard to murder of my brother, late Rijit Kurkalang, on 20th of March 2011 at around 2:30 p.m. while I was collecting the parking fees at Anjali parking lot. I saw two boys sitting in a local consuming beer. I asked for a parking fee from them, but they refused to give any. Since these two boys were refusing to give a parking fees, I called my brother Rijit Kurkalang. I'll just hold for a second here, my lord. My lord, I have read the FIR, my lord. In the FIR, this same complainant, he said 6 to 7 people were sitting. And now in the depositions, he's saying these two men were sitting and consuming beer. So, my lord, there's a huge difference, my lord. 6 to 7 versus 2 person. So, my lord, after some time, my lord, I'll just continue. After some time, my deceased brother came to the spot and we had a quarrel with these two persons who were not paying the parking fee. And after some time, both these persons left the place, leaving the local taxi at the spot. Later on, after some time, there were two persons came back against, along with people who were armed with hammer, iron rod, dagger, and assaulted us. And out of fear, I managed to flee from the scene. But these people continued to assault my brother, and after assaulting him, they fled away from the place. Now, my lord, this is supposed to be an ocular witness. He said, assuming that for a moment that what he said is correct, they said a group of people came armed with, started assaulting us. He ran away. If he has run away, how did he see? who did the overt act of assaulting his brother, by whose fatal blow his brother sustained an injury and later on succumbed to the injury. How did he see? So he is not an ocular witness. And my lord, I'll just continue. After I have fled away from the place, I went straight home and informed the relatives, and later on, we were informed that the police had reached the spot and saw my brother, who was badly injured, and took him to Civil Hospital Shillong for medical treatment, but unfortunately later on succumbed to his injuries on the same day. Later on, we received a phone call from our friends who were working as parking lot attendant, and they told us that my injured brother has been shifted to Civil Hospital Shillong by the police, and on reaching the said information, I, along with my relatives, immediately rushed to a Civil Hospital Shillong, and when we reached Civil Hospital Shillong, he was bandaged and was conscious, but later 10 to 20 minutes he succumbed to his injuries. Later on, I lodged a FIR to the Cantonment Police Station. This statement, my lord, further fortifies that he was not on the spot, because he needs to be informed that your brother is lying injured and we are shifting him, or somebody is shifting him to the hospital, which means that he has not seen anything. So therefore, he cannot, again, my lord, just to reiterate myself, he is not an ocular witness at all. He cannot be, his evidence cannot be relied on, my lord. The FIR was written by the in-charge Mr. Singh on being narrated by me, and after being satisfied, I had put my signature on the FIR. Exhibit 5 is a FIR lodged by me, and Exhibit 5/1 is my signature. I also remember that I was also asked to identify the accused person, and identification was conducted at the District Jail East Khasil Shillong, and the same was conducted in the presence of one magistrate. Kindly note, my lord, the TIP was conducted in the presence of one magistrate, my lord. I'll come back to this later on, my lord. In the said test identification parade conducted at the jail, I was able to identify both the accused persons, and these two persons are also present in the courtroom today. Witness pointed to both the accused persons who are standing in the courtroom today. Exhibit 6 is the identification of suspect report. Exhibit 6/1 is my signature. I do not remember whether my statement was recorded by any magistrate, it has been so long. Now, cross-examination. I had drafted a FIR. I went along with the police to lodge the FIR. Chief, he said, why minute things I'm pointing out, my lord? Because I'm saying that this is not reliable. Chief, he said, Mr. Singh drafted the FIR on my instruction. In a cross, he's saying, I drafted the FIR. Now, my lord, I am working as a parking attendee on the day of the incident had occurred, and that time we charged 30 for whole day for parking fee. On the day of the incident, I had asked the parking fees from the person who is also present today in the court, since he was sitting in the vehicle, and there was also another person whose name I do not know. I do not know whether Comius was a passenger or a driver, but he was sitting inside the vehicle. Now, my lord, TIP, my lord, here, he names an accused person. Accused persons were not supposed to be identified. It was somebody who was not known to them. Now suddenly he identifies a person. Say that Comius Dodong was, I don't know whether he was the driver or he was a passenger. How did he come to get this name now? Now, my lord, suggestion. Counsel suggested that as per the statement of Sri Sylvester Khongsit, during his cross-examination, he had stated that you and your deceased brother were drunk. The answer is, I do not agree to the said statement, since I and my brother were not drunk on the day of the incident. Now, Sylvester, who has been all along with them, in his statement, I'll read out later on, says that these two brothers were drunk. Now he says that I am not drunk. My brothers were not drunk. I was not drunk. Contradictory among friends only. It is a fact that there were many people who had assaulted me and my brother, but I was also like to state that clearly the two accused persons who were present today in the court. At the time of the incident, my elder brother was at Foreign Market, Bazaar, Yodo, and I went to call him from there. It is not the fact that I have stated today, is what I have never seen what had happened to us on that day. It is not a fact that I was in the custody of the jail at the time when the TIP was conducted. So, my lord, reading this, I'm not even showing 164, my lord. Reading in this statement with the FIR, my lord, there's so much of contradictory statements is just coming out, my lord. So we cannot rely at all on the statement of PW9. My lord. Now, my lord, we'll come to Silver's statement, my lord. Who is the another witness, my lord? That's a page 56, my lord. These two are ocular witnesses, my lord. So purportedly said to be ocular witnesses, my lord. Page 56, my lord. Now.
Yes.
My lord, I may read. I know that this case, it was Sunday Holy Festival in the year 2011. The younger brother of the deceased called up his own brother, who was with me at that time. After we went to the spot, the incident had already taken place, and 4 or 5 people came to us and started assaulting both the brothers of the deceased, but they did not do anything to me. I can identify only 1 out of the 4 or 5 people who had beaten up the brothers of the deceased. The brothers of the deceased on that day, and the accused is present in the court today. The witness pointed out at Lewis. Cross-examination. It is a fact that in the year 2011, there were many people celebrating Holi. When the deceased brother called up his elder brother by telephone call, we were both in the marketplace. It is a fact that I was not present at the time when there was a fight at the parking lot. It is a fact that the deceased is my friend, and deceased during his lifetime is a member of the KSU. It is a fact that both the deceased and his brothers were drunk at the time of the occurrence. It is a fact that I am not working in the parking lot for collecting. It is a fact that during the fight they were running. The conviction is not sustainable. One other accused has been acquitted by the trial court itself for lack of identification. 2 others who were tried separately have also been acquitted. Mr. So-and-so, my lord, will just skip paragraph 6 and paragraph 7. Now paragraph 8, my lord. We have considered the submission on behalf of the parties. The FIR was registered against unknown persons. The case of the prosecution solely rests on identification in the TIP. The acquittal of the appellants under section 412 IPC and the Arms Act has attained finality. No doubt, the test identification period was conducted within about a month of the occurrence. It has also to be kept in mind that PW2 was a minor at about 13 years at the time of occurrence. 9, my lord, a test identification period under section 9 of the Evidence Act is not substantive evidence in a criminal prosecution, but is only corroborative evidence. The purpose of holding a test identification period during the stage of investigation is only to ensure that the investigating agency prima facie was proceeding in the right direction, where the accused may be unknown or there was a fleeting glance of the accused. Mere identification in the test identification period therefore cannot form the substantive basis for conviction unless there are other facts and circumstances corroborating identification. But more important than that, the test identification period being a part of the investigation has to be proved by the prosecution as having been held in accordance with law. The onus lies on the prosecution to establish that the TIP was held in accordance with law. It is only after the prosecution prima facie establishes a valid TIP having been held, the question of considering any objection to the same arises. If the prosecution has failed to establish that a TIP was properly held by examining the witnesses in the same, there is nothing for the accused to disprove. In the present, a magistrate is stated to have conducted TIP. The magistrate has never been examined. No explanation is forthcoming why the magistrate was not examined. The only evidence available is that PW4 of the station house officer that during the investigation the TIP was held in the district jail, Nainital, and he identifies the proceedings in the court. The identification of the proceedings is irrelevant, as obviously he could not have been present during a TIP. The TIP is the TIP, a part of the investigation, therefore cannot be said to have been proof much unless it was held in accordance with the law. Secondly, there cannot be repeated TIPs till such time that the prosecution is successful in obtaining identification recused. We find extremely disturbing that both the trial court and the High Court did not go into this aspect at all to satisfy themselves if any TIP had been proved to have been held at all, and that too in accordance with the law. Therefore, my lord, subsequently thereafter, my lord, the Honorable Supreme Court, my lord, held the TIP was bad in this case. Now the same case here, my lord, very much facts the circumstances. Two TIPs were conducted. First TIP, Louis was not identified. In the first TIP, Crow Cooper was not identified. Only Comius was identified. Second TIP was conducted. Louis was identified. The magistrate who identified was never examined. So how do you prove? How do you prove?
The same magistrate in both the TIP.
Same magistrate, that we'll have to see, but no magistrate has been examined. Even if, my lord, even if there was different magistrate or same magistrate, the bottom line is that it was never examined. Was never examined. So how do you prove? How do you convict me on the basis of? And this was overlooked by the learned court below, my lord, while convicting me, my lord. And it went on to other evidences, and other evidences also, the star evidences, I've read it to my lord. What did they say? Both of them are so much contradicting each other. And even in the wildest of imaginations, my lord, we cannot say that these are trustworthy. Now, my lord, that comes now. Who are these two witnesses now? These two witnesses are the interested witnesses, my lord. Babing Jair has been continuously saying, my brother died, please punish me, punish them. And his evidences are not here and there, everywhere jumping. Not even one word came that he is the one, I saw him. And even if I saw him, whether he hit with hammer, rod, where is that weapon? Other one, his friend is saying that no, both the brothers were drunk. And how unnatural it is. When your friend is lying injured, you didn't even take him to the hospital. So, my lord, these two, the learned court below heavily relied on this while overlooking entire the concept of TIP, whether TIP was conducted in accordance with law or not, whether the magistrate whether the prosecution was able to prove that the TIP was conducted in accordance with law or not, completely overlooked that and went on to rely on these two PW1 and PW9, who were not even at all worth mentioning, that they are very ocular witnesses, my lord. Now, other witnesses are not important, or they're all here and say witnesses, my lord. Now, having said this, my lord, I will just show one more witness of the IO, my lord.
We'll continue next day, Mr.
Oh, my lord, yeah, my lord. Parhat, and then next day, my lord, my lord.
What, Mr. Yogin, one letter counsel for the appellant. Hearing is not concluded. I will continue at the next date fix. Accordingly, this is matter after 1 week.
My lord, obliged.